No worries at all.
Everybody's ready?
Okay, we'll call the meeting to order. A little bit gentler on the gavel this time.
Yeah.
Working on that. Can we call roll?
Vice Chair Rumsey,
Here.
Lou Ramon,
Here.
Valerie Lundy,
Here.
Kevin O'Neill,
Here.
and Chair Nick Abercrombie.
Here.
Perfect. And then I also want to note that in attendance, we have our planner two, Dave Burgess in the back, and then two of our new team members, Grant Atai, our permit technician, and then Rick Dieter, our co-compliance specialist here. Unfortunately, CJ had something come up, so he is not able to join us. And then, of course, I'm Karen, the planning director. So Pledge of Allegiance.
Okay.
I guess what's next on the
Let's do the
agenda?
Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, well, given that we have no items to discuss here in terms of variance requests, we'll move right into our work session.
So yeah, this evening we have with us our city attorney, Nina Williams, who's going to do some training with the Board of Adjustment. You know, you guys attended a joint work session with City Council. I think it was back the beginning of June. And she covered a lot of things that are common to all of our various boards during that meeting. And so wanted to make sure we spent time with just the Board of Adjustment, since there are things that are specific to you all that are a little bit different. Your charge is a little bit different in terms of what you hear and review. And just wanted to make sure you guys had an opportunity to have all your questions answered, additional guidance from our attorney. And then because I've got new team members using it as part of their onboarding as well. So this timing is perfect for all of us. So with that, I'll turn it over to Nina, and it's all yours.
Thank you. And some of you or all of you have met Betsy Stewart. Oh, I didn't mean not to put her last name on there. Betsy Stewart is here. That's her email address. So you have both of our email addresses. It's great to be here. I actually made my segue into Woodland Park in 2019 or 2018, just when Jason Myers asked me to represent just the Board of Adjustment. That's how I got to know Lou. And that was a very interesting case, and actually gives good color for this type of training, because it's always good to talk about these issues, you know, in a workshop, in the hypothetical. So then it's a good reminder when, you know, a hearing like that comes along, where of course there's, you know, a lot of feelings and that sort of thing. So you can go back to that, go back to this, this training, and think it's a good resource. That's why I, you know, emailed it to you all so you could save it and that kind of thing. So I thought it was good to just go back to the basics, what is in the code, and then through there, we're going to talk about variances and appeals. And then we're also going to do quasi-judicial. I think it's important. I know you all heard it a few months ago, but I think it's a good reminder. And please interrupt me as I'm doing this. I want to make sure, like, it's collaborative. I'm, you know, kind of helping you where you're at. This might be repetitive for some of you, but for some of you who are newer, or even if you're not newer, just please ask questions. It'll help. So, you know, there's 5 members appointed by City Council, 2 alternates. So in the absence, the chair is actually the one, and that's different from other codes. Sometimes it's like a vote or whatever, but the chairperson is given that responsibility at the beginning of the hearing to say, this is the person who's going to serve as the alternate.
Sorry, trying to find the button. We are still looking for alternates, right?
Yes.
So, you know, this may in fact not come up. If we had 1 absence and 2 alternates, is it the chairs just basically gets to pick?
Yeah.
Okay.
You guys didn't just distinguish that in your rules of procedure, right?
We did not.
Okay, which is fine. Yeah, so it's a chair. It is a lot of responsibility on here.
Yeah.
Well, I don't know if Lou, if you wanted to talk about how you've done in the past, maybe you've alternated, or you've had that general sense.
Yeah, what I've tried to do is, if we have those occasions, I would try to alternate between the alternates.
Yep.
But, you know, generally it's who's ever here
Right.
is
Who's
that, you know,
available
the
is-
starting 5.
Yes.
Because I can remember one time as my year's alternate, I was here and a member was excused and I was asked to come in as a member. So, and Lou was chair at that time.
And for the Board of Adjustment in particular, it's important to try to get those alternates. Hopefully the city could post for that. Because you need the presence of 4 and the vote of 4. Whereas in another board, it's usually the majority. That comes from statute. So there's a death, resignation, or removal of any of a member or an alternate. The council appoints you also. If any of you have just cause or more than 3 consecutive absences, the council can remove you. That's typical in different codes. It's just there, just so you know.
Now, if one of us were to move out of the city, we would no longer meet the requirements of being on the board and we would resign or be resigned.
It's better for you to resign so everyone knows, because there's been situations where that exact situation has happened and the council has had to like push the issue, say, we're gonna bring this to a hearing if you don't resign yourself. Just so there's something in writing, that could be an email to you all. Unfortunately, I've seen some worst case scenarios. And then that's everywhere. That's not a dig at Woodland Park. That's everywhere. It's just, I represent local governments, and local governments comprise of people, right? And people are imperfect. So every time the first of the year, you elect your chairman, that's in the code. That's very specific, again, a lot of codes don't do that, but that's good for you guys to reiterate the faith that you have in the chairman. Because again, the chairman is the one who picks that alternate, who calls the meeting, who calls for the recusals, that kind of thing. So you all know this, but it's good to remember that it's 4 votes necessary. Even if there's 5 of you and you think, oh, 3 is a majority, 4 is necessary for a reversal or a variance. Only 3 is needed to maintain an order or to approve minutes, that kind of thing. And I know that case that we had in 2019, that was big, but yeah, it was like, you need this many votes, this many votes. The board secretary is identified as the designee of the city clerk. I imagine, is it you or Christopher or Chris, CJ? The board who takes the minutes.
We actually have another staff person
Right, okay.
who does the minutes
Right.
behind the scenes. So who the official designee is, probably the director.
Yeah,
Because
that's
the
what I've seen.
director then has the ability to also delegate. So-
Right.
Yeah, I mean,
So it's not a member of the board meeting, so it's a staff member.
right, and technically that secretary is assigned to the clerk's office, or the clerk is responsible for that. Now, in our rules of procedure, and one of the things we might want to change in the code, just simply because it involves more than just it's outside the planning department. We've got some special considerations that we've said that if we had an appeal, the secretary of the Board of Adjustment would have to be someone who was not in the planning department. And that was just to preserve the appearance of being, having
Yeah, right.
no conflicts at all. And now that's a once in a decade thing. So if that were coming up, we'd work with the clerk's office to get somebody temporarily assigned for the meeting.
Right, because otherwise the optics is Karen's taking the minutes and then she gets up and she goes in front of the dais.
Right.
But although now Karen has good planners that work for her, so there's usually CJ has been doing the presentations lately. Or lately being the last couple of meetings I've attended. And then, the code specifically says that you could adopt the rules of procedure, which you have, as long as they're consistent with the code. So then the next slide talks about more parts of this section 1851, which is all about you all. This is important. We're going to talk about conflicts of interest, but it's in this section of the code. So it's not just case law and general land use law that I share later on. It's specific to your code. And again, in this case, a conflict of interest, the chair appoints the alternate. So what in your code here defines the conflict of interest is direct or indirect interest in the property or a decision relating to such property. Then that person, you should notify the chairman of in advance of the agenda, and then you're disqualified from discussion, decision, or proceeding. So, that means even though think you're not going to vote, you could keep quiet, maybe sit in the back of the
Well,
room or leave.
What our rules of procedure say about that
Mm.
is if someone recuses themselves, they leave the dais so that there's a spot for the alternate to sit at.
Yeah.
Kind of hot bunking, as it were, but then they can participate in the conversation, from the public standpoint, when the public discussion is opened, but they have no voting, they have nothing
Right, but,
like that.
and I think they can participate as a member of the public.
as a member of the
Right, so-
public,
so
not as a
not-
member of
not
the
as-
board, right?
Correct,
As a member
yeah,
of
yeah,
the
so
board.
just like anybody else, they can get up to the dais and make a public comment if they choose to.
Yeah, and if it was me, I wouldn't, but you could do it if you want. Because, you know, if we're talking about like a true conflict and you are gonna either benefit or be financially harmed if that application moves forward, like let's say it's your competing business that's going for a variance. If it were me personally, I would just, you know, sit and quiet. But yes, there's been a lot of discussion even in case law about, you know, First Amendment rights and that sort of thing. And yeah, making it clear that you're there as a member of the public, but I always share what I would do if it were me, so. A public hearing is required for appeal of variance. You guys do this, but this is where it is, all in your code. The notice of public hearing goes to, it just says adjacent property owners, a sign posted, and notice in the newspaper. And what can you guys do? You already know, but you could reverse or affirm, wholly or partly, or modify. And you have the powers, this is unique because I always, in even the slides that you might have seen me give a couple months ago, I tell the planning commission, you can't create your own application. The applicant is in front of you, but when it's an appeal, you are given, and this is in statute as well, as a Board of Adjustment, the powers of the officer from whom the appeal is taken. So you could maybe rework that letter of decision or that sort of thing, if it makes sense. And then you must decide appeals within 45 days. I remember that one that we were working on 5 years ago. That was like, oh no, we're gonna have the right amount of people, and then it was continued. And so it is a tight time frame, but that's just because everything stayed and you want to make sure no one's property interests are hurt too much, but also that the appellant or the applicant knows what's going on.
What happens
Yeah,
from a standpoint if we don't? I mean, if we don't decide the appeal within 45 days, I mean, there's nothing in the code that says
I'm
what happens? I
frequently
mean,
asked
somebody
this
throws a-
question, and not just about
gives us a
appeals.
red card or what?
Right,
Yeah.
right. The person would
that.
probably have to go into court for a specific performance. I would say it would lend. If that person, whoever is like not happy with the decision, it would kind of lend not a good case when they go to court, right? If they're gonna say, well, they didn't even hear my decision, so it wouldn't look good in that sense. We try to, especially as the city attorney, we try to have our city follow our own code. But yeah, so if what would actually happen if that didn't happen, there would have to be you know, a pushing of us following our own code, but then that would turn into even larger issues if we weren't doing that, you know, uniformly. But I would say the most practical thing that I would worry about is, again, adding kind of an argument when the person went, or just even their mom, you know, when they went to court to appeal your appeal decision in district court. You know, they didn't even follow their own code, that kind of thing. So we try to follow the code because.
Oh, yeah, no, I'm not suggesting.
No, I know.
But
No,
I was
but I've
just
been asked
wondering what
that,
happens.
I've been
if-
asked that in agreements, like, well, what if we don't follow an agreement, or what if we don't follow, you know, it's been.
Well, the specific question Lou was asking prior to the meeting was, what if we can't get a quorum?
Right.
You know, and it keeps getting pushed out because we don't have a quorum of people to actually hear the.
Right, like you said, what do we get, a red card? I would recommend sometimes I say least worst option, right, is maybe to document that. Even have your meeting, even if there's 3 people and you're not gonna do any public business, but you're gonna say, we're trying to make core, you know, we're trying to get enough people here. We're gonna reschedule it for 10 days. We know we're gonna go beyond the days, but it's obviously more important to have a public hearing. You need those amount of votes. So yeah, sometimes you do the best you can. I call it the least worst option because it's like, yeah, I don't really, it's not like something I would advise, but it truly is like the best option with what we're given. But in that case, I would probably document it. So it's just clear for the public, for the appellant, we're doing everything we can. You are ultimately a volunteer board.
I don't remember if the days thing was calendar days or it was back to that whole thing, calendar days or work days, or what if there's a holiday?
The code says 45 days, so that when it's in the absence, it's just a calendar day.
Now,
But I know in your procedures, you talked about.
in the
Yeah, we
stuff
did.
that we had when we recommended some code changes.
Yeah,
Clarifies that, talks about what
Right.
happens.
but it,
And that's still going
but
through
it's
the
still going
planning
through the
department,
system.
so.
Yeah, okay.
And that was a question the planning department raised
Yeah.
at their last meeting too, is what happened.
Well, and part of what happens here is we've been talking about the code rewrite for like 2 years.
Yeah.
We've been working on it very slowly, painfully, methodically. And I don't remember all of the details because there's limited disk space up here. And I know we have already dealt with computation of time and how it was being addressed. I think Valerie was there for one of those meetings.
Yeah,
So we've already gone through that, and I think we were headed towards calendar days.
yeah, I think so. I don't remember either,
I
to be
think
honest
we
with
were,
you.
but there seemed to be some confusion at the last.
Because I don't
Working group.
remember to like spit this out every time we have a work session. I've moved on to other things. We've already addressed it. It's
Oh,
in
yeah,
the
but the
draft.
planning commission didn't remember it either.
But because they recognize we've already addressed
Yeah.
it. I believe it's part of the definitions chapter.
Yeah, I think so. And there was.
They shall be defined as.
There, and when we first talked about it in that review thing, not here, there was the whole thing, because there were some of the planning commission guys were going based on the land movement stuff, which had its own rules, which were different.
Yep.
So I think that's where we worked it out, I believe. That's,
It sounds right. Like I said, I'm real
Yeah.
sure I'm real sure. We landed on calendar days, which is a very normal and contemporary way to calculate all of
Makes
this.
it easier. And from a practical standpoint, to answer your question, like what if we couldn't get to a hearing? What I would recommend is an agreement, like a letter signed by the applicant saying, we agree that this appeal will be 60 days. That's what I would do. And that's when I was on the developer side. In another state, we would
yeah.
frequently be asked to do that. And of course, we're gonna sign. So that's a practical standpoint, but you do the best you can.
Yeah, that's a good idea.
Yeah, because what we were bucking is we were bucking, I think, a holiday and some weekends that,
Yeah, it makes it more complicated.
where does that fall?
Yeah.
Yeah.
And, so your powers include appeals, and we're gonna go into that more detail, variances. And then there's such other powers and duties. That's basically, it's either variances or appeals. Both are public hearings, both are usually quasi judicial. And obviously you also spend time, redoing your procedures. That's more legislative a policy, but here's what you do. Perfect. So we could break it down so simply. It's you either do an appeal or a variance. Most of what you do are a variance. So a variance is varying a Title 18 provision, so your zoning provision. We're gonna go into more detail in what 1860 provides. And then the appeal is the order, requirement, decision, or determination. This language is from statute from administrative officer. So, it was in the case about 5 years ago, a decision from the planning director was appealed from, she interpreted Title 18. And then we went forward from there.
Can I ask a question there?
Yeah.
Is, the planning director makes the most sense, right? Like who would get appealed, if you will?
Yes.
Are there I'm trying to think about other places. Is it
Would be
really
the-
the planning
would
director?
be
I'm
the
trying to think about where else. that might
Is it
be.
maybe the public works director if it's a streets issue, but would that be in Title 18? Maybe, probably not.
It depends upon how your code is written. is where
Right, so
we
sometimes
struggle.
it's public works because they're talking about the streets for a subdivision section.
Yeah.
Yeah, okay.
It's probably usually the planning director, because our building code, that's a different appeal process.
And some of it's just how the code is written in terms of what things can potentially be appealed to the Board of Adjustment. The floodplain regulations are an example of something that get appealed to the Board of Adjustment if somebody doesn't like the decision that gets made. And that's another one of those, who is the floodplain administrator? And the city engineer and I kind of rock, paper, scissors it out, and we keep kind of going, it's you. it's you.
And some communities will have a designated person.
So at the moment, it's not clear, and in a small community like this, sometimes that's variable depending upon the skill set of the people you have in the seats.
Yeah, okay.
Quite honestly, is part of what happens. So to Nina's point, it's all about just how your code is written and structured. One of the things you saw, I think, in the last work session on the code was making it much more clear that the planning director or designee. So even if somebody does bring an appeal in that, Grant made a great decision based on training and the people still don't like it and they want to appeal it and we're here in front of you, it's kind of.
Right, they can still
planning
appeal it because
It came out of the
your-
planning
it's the
department.
designee.
An
some-
administrative
some
officer.
Appeals will go directly to the city council,
Right.
If the
and
code provides,
others
yeah.
Depending on, the
are
code. Yeah, okay.
given to us, and that's defined in the code.
Well, and it says
Who it
administrative
is and what
officers.
they're talking about.
So administrative officer is usually a staff member and it's of that final like decision for something that doesn't go to city council, it doesn't go to planning commission.
Okay.
It's a official decision, something that's final, but again, something that's hasn't gone through the public process, because if it goes through the public process, or even to Lou's point, if the code provides that the appeal goes to city council, then that's the final decision that then they can appeal to court and you're left out of
So,
it.
so the planning commission, an appeal from a planning commission decision would not come here because that's not an administrative
Correct.
office. Okay,
It rarely happens, although your code might be going more administrative, so maybe it'll happen a little more, but.
Well, and here in Woodland Park, the way it's currently structured, planning commission has very little decision-making authority. They make recommendations that go to city
right, and then
council.
the planning
The
office or
flood,
planning
right,
director
the
actually.
floodplain permit is one of the few that's theirs in terms of a decision-making.
Cause they make a recommendation to city council.
Yeah, okay,
And then how do you appeal, this is a city council, you go to court or the court election, in a referendum.
okay, thanks.
And the appeals that come before us are very few and far between, about
Yeah.
once a decade, maybe.
Yeah, definitely. And I hardly see them in other communities as well. So we went over quasi judicial and ex parte. I just thought, important. I usually say, oh, it's not legislative. Hardly anything. Most of what you do is quasi judicial. So it's kind of actually easier for you all. You're doing variance, you're doing appeals. If you're ever at city council, liquor licensing, that's quasi judicial. But if you're creating rules, you're amending your policies, I'm pointing to your rules of procedure. The short-term rental ordinance that was about the whole city, the land use code, the zoning code, Title 18 rework. That's legislative, that's making law, but how you apply the law is quasi judicial. So that's most of what you do. So it's really important that we go over this, because most of what you do is acting as a judge. It's applying with the already existing code to the facts that are in front of you. So, it's important, not just because the lawyers are always, or quasi-judicial, or Karen's like, this is QJ. It really roots in due process, which is in the Constitution. You're not depriving property without due process. So the due process is all the stuff that we'll talk about here is the proper hearing, is that you're making your decision on objective factors, that sort of thing. And then it's also important that everyone sees how you're making the decision. So if someone's in it could be the applicant, but it could also be a neighbor, they are listening to how you're making your decision. They could, even if they don't agree, they should be able to understand how you came to your decision, because they heard the testimony, they saw the reports from the applicant, they heard the staff report, they heard you deliberating. Everyone heard in the same room or the same packet, right? Everything's either in the packet or it happened within the confines of that hearing. That's really important. And that's because for a fair hearing, you're the unbiased decision makers, and everyone should have the same input. And then anyone who disagrees with your decision, if they're aggrieved, they have standing, it's called, they can go to the district court.
Well, okay, that's one of the reasons that we don't want any of us to go look at a property independently before a board meeting or something, because that means that whoever looks at that has information that's not presented to everybody at the same time. we've had occasions where we've wanted to look at something and the planning department set up a meeting time and we all went
Noticed,
there
everyone could
together.
go,
In
yeah.
fact, the applicant went and even the public was invited. It was posted so that everybody hears the same thing at the same time.
So it's part of the public hearing.
So, go ahead.
I was just gonna say, but also, you know, based on the decisions we have, our various meetings, et cetera, that, you know, I know we had one case where we made recommendations. And then that person came back, what was it, 60 days later? Cause I was in Serbia, it was a year ago. I was in Serbia when the
Mhm.
meeting was done,
Yeah. I remember.
recommendations were made, the applicant reapplied.
Mhm.
And then they came back in. And, but I know that applicant could have gone to district court after the first one, but yet they reapplied and came back in and we all worked it out. But I know that they don't have, they can legally go to district court based on a decision of the BOA. But a lot of times, you know, we've been able over the years that I've been on the board to work out a win-win based on discussion and go from there.
Well, generally, if you appeal and go to district court, they're looking less at the technical aspects, if you will, but more at the procedural. Did we follow the code? Did we follow the letter of the law? Did we mess up that way? Because they're not, the appeals court judge doesn't want to take the authority or the responsibility away from the five of us.
Yes, the standard is arbitrary and capricious, so that a judge will only overturn your decision as the local body sitting in the community if your decision was arbitrary and capricious. And that's why we give all these trainings. We want to make sure that you're making, we'll never tell you substantively how to make the decision, but it's a fair process. And in your example of that person coming back, I've been in situations, we're on the developer side where it's like, you know, you're not gonna get anywhere with the city. So you feel like your only way to go is court, even though it's a high threshold. But because of the way you operate and the way you conduct your public hearings, and you show that you were listening and you're pointing to the code, that person said, okay, these are people who are rational. I'm, rational, they're objective. So that's a credit to you that person came back because of the way you conduct these hearings. You've been having a question for a while.
No, it's so slightly switching topics, but kind of over to the ex parte communication piece. So what is this? Ask this question. What is the standard or what is the reference point for this is defined as, I'll say, ex parte communication versus information? So, and I'll give you an example that didn't end up coming up because they withdrew the variance request. Across the street from me, there was a big sign posted that was, it was like, hey, like a variance hearing. Before I got the packet from CJ or whatever, I was like, oh, there's a sign, they're doing construction. Oh, that's my board,
Right.
and so it's like, oh, I was wonder when we're gonna get this packet,
Right.
and I was actually considering, I was like, well, I mean, it's kind of an interest. I'm sort of like, it's not really gonna affect my sight line. Is this a conflict of interest? And anyway, it went by the wayside because they pulled their thing. But I do have more judgment on that property, for instance,
Right.
than say, Jim. I don't know exactly where Jim lives, but I don't
Right,
think Jim and I are neighbors.
Yeah.
So, where is that threshold, or what's a rule of thumb or an idea to say,
Yeah.
ooh, we better call somebody?
Yeah, that's, I would say that's actually more, your example is more prejudged.
Oh,
or
okay,
biased.
sorry, yeah.
No, we'll go into
Right.
it. So, only and you're all diligent people and you're all, you're doing this for good reason. Only if you've been biased or you've prejudged to the extent that it wouldn't be fair. And the threshold for you, just as, normal people want to do right, is would you want you to be in front of you if you were the applicant, because you've already so only if you could kind of decide, or you could say, okay, I'm gonna put that away and I'm gonna follow what I've done.
Okay.
Ex parte is when someone reaches out to you, and where the ex parte is a problem is if it's an affected individual, or it's like the developer trying to lobby you. I do give the example of a neighbor coming up to you in Joni's, but in that case, I don't think that, we're not up to it yet, but the next slide I'll go into what you do. And I think in that situation, you say, thank you. I want you to make sure that you're heard, please come to the hearing, please send an email. And then it's up to you if you, at the beginning of the hearing, you could say, someone came up to me, I don't feel, I asked them to come, I see them here, I see their letter, everyone has knowledge. Where ex parte is, a problem is really like when someone's lobbying you personally, or if
Okay.
they're affected.
Yeah.
And that's where you should be like, you really need to say, no, this is improper, I'm gonna be the judge. Because if you go to regular court, you wouldn't want that one party has spoken to the judge, or, taken him for coffee before, or
Right.
bourbon, right? So you're the judge. So, you live in a community, people are gonna reach out to you. You're gonna say, I want to make sure your voice is heard. Please write an email, please come to the hearing if it's ex parte. Prejudgment, again, I'll say only in your example, only in other examples, it's an issue because everyone might know. So like, in city council a couple years ago, there was someone who was writing around next door, and we had to talk to them, and it was like everyone saw the post, so we had to, that makes the city look bad, so maybe I'll lean in a little more when I talk to that person. Or if you say like, I'm never gonna be in favor of affordable housing, and then the person comes in front of you for a variance to allow maybe a setback that allows for one more unit, and you just said you'd never be in favor. So, that kind of puts, it puts this, not just the city, you as a board, right? Your credibility as a board. Because you're members of the community and you're ethical people and that stuff. So I would say prejudgment bias, a lot of times when someone calls me, I go through it, I'm like, well, I actually ask some questions, which is on the next slide, but I'll go to conflict of interest first. Conflict of interest is very specific. It's personal or private financial interest. So like your spouse will be adversely affected if you approve a certain use that maybe is going to be the direct competitor of a business that they own. Or the spouse owns the property, and if you will allow for this differing setback, that's going to allow the business to achieve more revenue. So it's a very specific, and that you definitely, even your code says that you are disqualified. So that's very specific. The other two are, well, what should we do about it? Next slide.
But what Nick was talking about, that specific case is one when there could be a conflict or appearance of a conflict.
Right.
Because if they're looking for a setback variance or a height variance, it's, your view, your street that's affected,
Right.
the kind of ground rules that we've been generally, trying to work under is what would your mother think if she saw this written
Yeah.
up in the paper?
Well, and I think that goes back to the, like, what would you want if you were the hearing person,
Or is
right?
it-
It's a
yeah.
judgment call, and it almost sounds like there's, I hate to say there's not, but it sounds like the answer to my question is no, which is like, is there kind of a rule of thumb or a guideline? And there really isn't.
There's
And
questions you'd ask yourself, which we'll
yeah, okay.
go into, but so Lou, what did you just say? Sorry, I was already.
Well, it's the appearance that you're worried.
Right, so that was what I was gonna say. So sometimes a lot, like half the calls I get are someone thinking like, because their kids, Little League coach is the applicant, or your uncle's friend is a bartender at the bar that's applying. That's just, you live in a small community, you might know people.
Right.
Versus a true conflict.
And I think that's important, that we have to remember. We have to remember that because we're a small community and we've got the whole reputation of the Board of Adjustment to uphold. We don't want people to begin thinking that even though your objective is could be, but that they
Perception
perceive
matters.
that, yeah.
Well, I've been asked the question, why aren't you on other committees of the city? I said, well, first of all, it's in the municipal code that if you're a member of the BOA,
Yeah, actually.
you cannot. And they go, why? I said, we deal with a lot of things and we work with a lot of these different departments.
Yeah.
We have to remain unbiased, period. And they accepted the answer.
Yeah.
That's why I look, that's why I just tell them, we cannot, it's in the municipal
Just-
code. We deal with too many different departments and we have to remain unbiased no matter what.
Yeah, it's good.
I think this is a difficult town to remain unbiased.
Yeah.
mean,
You can
It's a
encounter that.
difficult town to,
so what I,
not be
Yes.
perceived as being biased.
Yeah, no, you can, having worked in multiple small communities, you can encounter that in any small community. So Woodland Park is not special on that end.
Right.
well, I've chosen to live in small communities, a couple of times, and I've spent most of my life in very, very large cities, but I do find it difficult as a member. Yeah, I've seen a couple of situations already where I have a very strong opinion about it, and I have to put it aside.
Yes, yeah,
Yeah,
yeah, definitely.
but I think this needs to be talked about a little bit because
You're humans.
it's a tough thing. I can, when I read the notes from what we're gonna talk about.
Yes.
I know what's happening and I have a very strong opinion about it.
Right.
And so it is difficult for these members to step back, let go of it, and make a mature call on it without it being a personal slam.
Oh, 100%. It's much, it's very, I always actually usually start with, and I didn't, but it's easy for me to say this, right? You live in the community. But that's why I go back to the reasoning, the fairness,
Yeah.
constitutional due process, and you all know that, but of course, it's not easy. It's easy for me to say all these things and there are good resources for you to turn back to, but it's not easy when you're in the moment. I'll not acknowledge that, definitely.
I guess the question is there a point where you realize that you really shouldn't be making a call? I guess that's an individual's.
Well, then that be.
I need to put my hand up.
that-
I need to be out of this.
Yeah, that falls underneath the reclusal.
Yeah.
If something comes up, then.
Well, we're so short on.
Well, we're in a bad situation,
That's
right?
Right, because the
Okay.
person has the right to have a decision made.
We never
That's,
round
And if
up
you
those
really
other-
can't make a decision, because it's just like, the case in 2019, there was like standing room only and people were screaming.
yeah.
And the board made the right decision, but of course, that's so hard. These are all your neighbors, like literally screaming at you. But I would say if it gets to that point that it makes you that have the hard decision, then maybe there's different board. And right, because that's when it's the hardest. And that's when they really need the people who can look past that and say, okay, this, in that situation, it was about, mobile homes and there was a glitch in the code, or it's like, okay, well, now for the code moving forward, we'll fix that. But the code said what it said when this person bought the property, and then but if it's, and I don't say that lightly. I mean, some people, it's hard when it's everyone, screaming and saying, well, this is what the code said, but I see 100 of my neighbors, and that's harder for some people than others. So I don't say like glibly, like, oh, join another committee, but there are other committees that are maybe like, the Parks and Rec, if to give your community feedback. But if you feel it's to that extent in that moment, consider recusing. Hopefully there's still 4 people on the dais.
And I was gonna say, based on the way things are worded and written, you almost need to figure that out before the hearing starts.
Yes.
Whether you're starting with 4 members or 5, because of how it's structured, that the chair appoints the alternate to fill in. You really don't want to, I wouldn't think, Nina, want to be doing
Right.
that like on the fly,
Right.
halfway through.
Because then you can't appoint an alternate, because the alternate wasn't sitting here, even though they're sitting there, they're not sitting here the whole hearing as a
Right.
judge.
Right.
Yeah,
And from, our standpoint, the best thing we can do to preserve our independence, is to try to avoid any of the direct contact, normally, any of the conversations, like you guys said, hey, I can't talk about that. And step away that way, and people accept that, and they will begin to respect it. It gets trickier in the situation that Nick had, where you've got to make your own
Right.
conscious decision. Am I gonna be able to look at this fairly, or am I gonna be biased? And if you're on the line, generally, I would say, take the conservative path and recuse yourself and we'll try to find those alternates. I guess
Yes.
Yeah, actually, if we go to the next slide, because we talk about that.
You need those alternates.
Mhm.
So, how do you cure, you recuse or you disclose, but then, you have a very particular code provision, which we spoke about, where you have to tell the chair. So these are the questions you could ask yourself, and you're gonna ask yourself, then you're gonna call me. I would say at least once a month, I have a conversation with either a board of adjustment or a planning commission or a city council. Let's talk beforehand about these issues. And then not only, sometimes the member says, okay, can you ask me these questions before the hearing? And I will do that for you. Or you could say, can you ask me these questions so that I can say to all my neighbors, or that one neighbor who's saying, you can't decide this case because of this tenuous link. I will ask you these questions, like literally these same questions, and you will say, no, 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 no. Like, is your ability to decide the case fairly, impartially, and based solely on the evidence affected? You would say no if it wasn't, and you want to continue. Does an actual legal conflict, does a perceived conflict? Did you express prejudgment bias? These are this, and I'll even ask more questions. So these are questions that you could ask yourself. So yes, again, I mean, people don't like lawyers because they say it's depends, there's no hard fast rule, but these are some questions. And like I say, ask your city attorneys, because we've seen it through, our years of experience. It's the issues that come up the most. So here's some just suggestions. Follow the process in the code. That's always the best. Look at the factors, and you do a good job with your checklist for variance and that sort of thing, as opposed to personal opinion, subjective feelings, individual preferences to, this wouldn't really look too good in the property. That's not a reason. Based on the facts, the law, the evidence. And again, the public hearing is the complete record. So again, that goes back to why you want everything nicely wrapped in a bow. You have the packet and you have what happened in the public hearing. That is all what a judge would look at. And that's all what you want people to look at to see that you made a fair decision. So you're the fact finders and you're the judge when you sit here. And then,
Real quickly, related to that, because I've run into this a couple times where somebody's like, oh, attach the written decision to the minutes the next time we review the minutes, or attach this to the minutes. And I guess the point I want to make is the hearing record consists of these different elements. You
Right.
don't have to attach something to
No,
the
no.
minutes. So there's the staff report, there's the testimony and such that happens at the hearing. There's the minutes that reflect what happened at the hearing. And then there's your written decision of findings. So all of that collectively is the record.
correct.
You
All in
don't,
the file, so to speak.
it is, so you don't.
Yeah, the
need
audio
to-
would go to the judge, everything. would-
Yeah, you don't need to tell staff, oh, well, we want to make sure this is attached, bring it all back with the minutes again. So it's like, no, it's, all those pieces go together. It's like on your plate, you got a fruit, you got a veggie, you got protein, it all goes together to make the meal.
And we'll never consider it not part of the record. So you have good people here.
Yeah, so that's how that gets covered. So, all right.
Oh, yeah, no, these next two slides are just a resource. You can look back at it. I wrote this actually in 2018 when I had a different name. And it's just a different way to say the same things that we talk about. And the reason why we reiterate this in different ways is it's mostly how you're going to explain it to the person who doesn't understand. That's the resident. But I think fairness, or even what you said, what resonated with you is how would you want to feel if you are in front of a board? And it could be anything. It could just be a small addition. Well, not like your small additions go in front of planning commission, but if you want to make some kind of renovation that happens to go in front of a board, you would want them to decide fairly, and that you read the code, you did everything you were told, and just because it's irrelevant that you think the code should be written differently. That's why we're doing the land use code rewrite, or any ordinances that amend the land use code or your Title 18.
And this
That-
art,
that- Go ahead, I'm
I
sorry.
was gonna say, this article I did extract out of the PowerPoint and blow up so it's legible. We will get that routed to you, so you don't have to worry about trying to read all of this. So we'll get that emailed to you.
The bifocals and fine print.
Yeah.
Yeah.
At a certain point, 0.02 font is just not gonna cut
No,
it.
yeah, not for me either. You all do these things, but this is good affirmation for yourself. I've seen you for many years. You conduct really good public hearings with thought, with deliberation. So these are just reminders. It's not meant to be, preaching. So, reminders that people feel it was fair and their views were heard. Now, 100% of the people are not going to, because some people, they don't feel that's a fair decision unless it's one that they wanted, right? But for the most part, people will feel it's fair if you do all the things, continue to do all the things that you're doing.
Well, and
yeah.
that's why at the end, either in the motion or in the summary that the chair makes, we'll go through, and Nick has done this, we've gone through each of the points that are the basis for approval and specifically address our feelings on each one of those so that it's clear.
You can do it in deliberation or you can
rationale
do that
is,
in the
yeah.
vote.
Yeah.
Yeah, think out loud, I call it, yeah. So, I know you've done this before, especially when there's a lot of people in the room, you announce the rules at the beginning. I think that's 95% is people say, okay, they were told this, like, they know that they're only speak 3 minutes, or they know this is the way it's gonna happen. This is the order of events. People like, and then you have to stick to it, what you said. You can do some of these things, suggest to people. So like I would say, again, 80% of the times that does work. Some people will come up and they'll be like, okay, yeah, everyone said what I wanted to say, but I want you to know that I feel it too. Then it cuts down a few times. And cutting time, it's so interesting because a lot of even council members in different communities, they think if you make a hearing a short amount of time, you're stifling public participation, but it's been proven that when hearings and meetings are not super long, it actually increases public participation because people are either have families or they have jobs the next morning, and you're still going to be deliberate, but it doesn't need to be that everyone needs to speak for 15 minutes. It's fair to say 3 minutes because it's also for the person who wants to watch how you guys are doing things. But they have a kid who's waking up at 5 a.m. in the morning, and that actually increases public participation. So, and that's been proven, yeah.
If we, sorry, did I? you wanna-
I was going to go ahead.
And I'm trying to remember exactly the rules of procedure, and I know we worked this quite in detail, right, of the total time, and that the chair can make 5 minutes apiece or limit the time.
Yeah,
for
we used
people
to
and so on
have,
and so forth.
do you still have it?
But is there, I want to ask this, is there a requirement that everybody gets to speak? So let's say we made the rule 5 minutes. I don't know how many chairs there are, but let's say there's like 85, 90 people in this room and everybody signs up and says, I want to all talk.
Then that's when I would go to, if a large number of people have signed up, announce at the beginning, it's that we're actually going to change to 2 minutes. That's more fair than you get to the 60 people and you tell the other 25 people, sorry, it's getting too late. So that's why I think it is fair as long as it's uniformly applied, even though your procedures might say 3 minutes. If you do see that 85 people, you're going to say, listen, everybody, so that everyone could be heard while we are still have our minds with us. We're going to ask that everyone limit their time to 2, not only they limit their time to 2 minutes, but also if someone already said what Jürg said, please come up and say that I join in with what everyone says and sit down. So I would say it's better to do it at the beginning. That's why we say this than to, again, let those last 25 people and you tell them they can't speak, that's more crushing.
Okay. Well, I mean, is it legally, do we violate something by not letting them speak as long as we followed our person? I'm all for letting everybody talk. I hear what you're saying. I'm just curious if there's any kind of public hearing law statute.
So it all, people always like, actually I had a board of adjustment and a planning commission member in another city would be like, cite to me a statute from what you're talking about. It's based on like case law and interpretation and that sort of thing. I would say you definitely should try to let everyone speak, even if you say change it to 1 minute for everyone to speak.
In general, it will go better. How about that?
Yes.
Like not, yes, okay.
Yeah.
Well, that's why we wrote into the rules of procedure a time cutoff and being able to, the board has to decide whether we want to continue on or whether we
Yeah, cut it. Right.
cut it here and we'll pick it up at the next.
Well, I'm gonna say this, as our board, this board here has been together for many years. And our leaders, Lou and Nick, have done very well, presenting at the beginning. And even
Yeah.
when people have, I remember one case we had, Lou, I remember you were 3 times asked the person, your time was up, but yet you were professional about it, you were patient. And then that person did finally get the hint. So we as a board and our members, we work very well together. And our leadership has helped bring us to that. And I'm talking about Karen also, I'm talking about Nina. We know the importance and the decisions we make, how important they are and how they can affect the city or the applicant.
Right.
I mean, it can go,
Yeah,
it can get ugly if we do it wrong.
right.
So I just want to make that point that we appreciate all that you've done for us, these trainings, these hearings,
Yeah.
but we've had good leadership in Lou.
It's ultimately all up to you in those moments, it's how you are acting. That's all it is. It's like all you. And you guys have, yeah, held yourself with the decorum because it's like, well, it's two reasons. People are less likely to sue if they feel it's fair, but also they're less likely to feel if I'm in a room and I see that there's 100 people and you say from the beginning, I'm sorry, everyone, we want everyone to speak, but you have to keep it to 1.5 minutes. People, they're gonna feel much less incensed than if you get to the 40th person, they'll be just outrage. But if you said at the beginning, this is for everybody's sake, so that you have a board that is functioning by the time we need to make a decision, you explain all that, and then at least everyone still gets to be heard. There's not gonna be a person who's so aggrieved that they wanna sue, but more importantly, honestly, hardly anyone does sue. I am here for you to preserve your decisions and the sanctity of them and the respect in the community. That's mostly my goal. Yes, I do wanna keep your city out of court, but I would say 95% is that you are here working hard and you want to make sure your decisions are respected by most people. Some people are going to say, well, you didn't go the way I wanted to, but by most people. So that's why I always say, like, at the beginning, talk about the ground rules and not having someone speak. Yeah.
I did some orientation for city council and then often, new board members and such. One of the points that I've made through that is it's the predictability of the process that gets the boards their credibility. People know that this is what I'm gonna get. That it's gonna be fair. Everybody gets the opportunity to speak, even if it's only a minute, everybody gets that opportunity. And what is said is taken into consideration. It's not minimized. So all of those things go to your credibility, which then builds the credibility and trust of the local government. So you guys are a critical part of doing that for this community. So to Nina's point, that predictability gets the credibility this community.
Yeah, because then if that one
deserves.
person says, well, why don't you do this idea that I just came up with, and they feel aggrieved, everyone else in the room is like, no, but this is how they always operate. This is what we expect. There's always going to be people who are like, grievance martyrs, but most of the people are going to be like, okay, yeah, this is the way they always do things. And then when you are changing it slightly, like, for example, when there's 100 people in the room, you're explaining at the beginning, you're treating everyone the same. That's mostly, and giving your respect. You do this again. But I've seen other boards where people are like snickering or texting, like, you don't do that, but I don't even need to say that, but it does build the credibility when you're not like other boards I've seen. And thanking the person, they are, it's funny, actually, my next door neighbors, they're building next to our development, they're building like townhomes and apartments, and they're like, can they do this? And like, should we go to the meetings? And I had like I was like, oh, these are the people who come in front of me and I see something so objectively, it's so easy for me to see. And it's like, no, that person, yes, what they're saying might not have any objective basis in the code, but this might be the only time they come to a city meeting, right? They're a part of the community. So I've seen you guys do a good job where even maybe slightly for a few minutes explain, thank you, everyone. We heard you, but we had to go this way because of what the code said. It's invaluable, honestly. Brings a tear to my eye. You guys do a good job.
And one of the things that helps us and that Karen's guys do is have the sign-up sheet up there so that when we start the meeting, you know how many people have signed up. And so whether just your judgment.
Right.
Do we need to cut it down to 2 minutes? Do we need to do something like that? And you can have the rationale that we got 75 people signed up. So in order to try to come to a decision this evening before our cutoff time.
Yeah.
While you're all here, while you either got a babysitter or had the spouse, take off from work to watch the kid, or or the elderly family member, you know.
Okay, so let's take a slightly different tangent, because I know you've seen this before, Nina. These 5 people decide, well, we're gonna give Bob our 3 minutes each, so Bob gets to talk for what, 3 times 5 is what, 15 minutes on behalf of all of us. Guidance, recommendations?
Yeah, I've seen it happen. They defer. I've seen it allowed, and I've seen it, you know, I think maybe if it's a large meeting, you think that's gonna happen again at the beginning of the meeting, you say that we're not gonna allow that if you don't want to, versus like in the middle of it, maybe anticipate it.
Okay,
That's what I would do, or have it in, you know, your rules.
Yeah,
It's not,
Personally, I think if it's declared when they start talking, I don't think it's offensive, especially if you'd had, you know, let's say you had 75 people sign up. And they're gonna get a minute, well, this little group maybe says, well, okay, it'd be better off if we had 4 minutes straight and you do it. And I don't think that's a reason to reject it.
now, well, the council had some rules on that. I don't know what they've done now, but I know they used to not allow that. In our rules of procedure, we put it in that says, yeah, we do allow that because we felt like
Yeah,
yeah,
I
it's not
do-
gonna add more time, but people have to understand that beforehand.
right.
But I think we also, in our ROP, we would give them more time, but it wouldn't be
Oh, no.
full length. We
15
would just
minutes,
give
yeah.
them a reasonable amount of time if one person was a spokesperson for 3 or 4, because those 3 or 4 did not want to
Some people don't want to go to the mic.
go to the mic.
Yeah,
And I think we covered that in our ROP. They may not get let's say there's 5 people and we were still at our 5 minutes. But I think ROPs, we would give them more time, but not the full 25 minutes.
we
for
didn't
one
get to
person.
that detail, fortunately, in the RLP, but I think we've got that leeway. And before we open for public discussion, the chair or alternate chair would let them know some things like that, would let them know, please don't repeat what the other person has said. If you agree with them, just say, I agree with what they've said and step back. We understand that.
Yeah, move on. Thank you. Well,
Yeah.
thank you for your brevity.
Yeah.
Yeah, no, I think that makes a lot of sense and I think it's very helpful. But again, I'll just go back to, the piece of this that struck me and I took a couple notes, right? Say what you're gonna do, then do what you
Do what you
said. So
said.
I think
Yeah.
we're there.
That's the big thing.
And again, go back to, as much as love a good statute quote. I think what I'm hearing, right, is being consistent and explaining the rationale sort of on the record, being upfront with these are the rules, and then following the rules, you're gonna get further with that. And again, rules.
It's a
procedure, good,
defensible,
let's-
fair decision, but
yes.
it's also the credibility with your public. It's both
Yeah.
those things.
Yeah.
The fair, the due goes back to due process. So when you say, oh, is there a statute? I mean, due process has been interpreted by thousands of cases, in different scenarios. So it's just, it goes back to the fundamental fairness and treating everyone the same and doing what you say what you
Yeah.
do. And again, at the beginning, if it's gonna be a lot of people, addressing all those different types of things at the beginning. You get the buy-in from everyone in the room. These are the rules that we're all gonna play in. Not just us, everyone. You kind of get buy-in when you say it from the beginning versus I've been in funky situations where it's like midway and it's like, ooh, no, and that person feels like they are being treated differently, right? So that's.
Yeah.
And when there's high emotions already, you want the majority of the people to not just feel like it's fair, it's a fair process. You guys are putting that out there. So we can go to the next. So this is just your outline. It's good to have. I know you guys have a specific one. And I think you said you usually go over it. So people know that, okay, this is when I'm going to talk. And then the appellant or the applicant always has to have the opportunity to rebuttal across. I hardly ever seen cross-examination, but to give their rebuttal closing statements. You could ask your questions throughout. I know that's in your procedures, but some people you know, it's like they want a special time. Okay, now I can ask. So the questions could be of the planning department, you know, this question came up. What do you think about from your expertise? Or applicant, can you please clarify what that person said about the alley? Or, you know, city attorney, what does the law say or the procedure? Or, you know, so you can bring up people to answer your questions. And then you should try to answer your questions and then you deliberate. And then you make your decision. And, if you go to the next slide.
If I can ask that, sometimes it seems more appropriate at the time, if the city staff is giving a presentation as example.
Right.
We might ask questions
Yeah.
sort of in the moment. I'm assuming that's okay as part of.
Yes, except yes, and I have seen where it then veers off. So you want to make sure, yeah, you clarify everything to that factual questions. But then I've seen it veer off even to like what the applicant is going to say, or then like kind of opinion and or things that you've read in the letters. And then it's like, ooh, let's get to the rest of the hearing before we delve into that. And again, that's more of a gray area, but yes, you all feel like asking questions, but I would say more clarifying factual questions about the presentation you just heard.
Okay, that
Thank
makes
you,
a lot of
Amy.
sense.
And from a staff perspective, we do try to stay just the facts. You notice that we don't opine about things, we don't cheerlead things, we don't dismiss things. It's like, what are the facts? What does this look like under the code? That's where it stops for us.
I'll compliment you. Your and ZJ's presentations are exceptionally boring and very well done. So.
Oh, because they're fair, yes, they're not,
I mean that.
Yeah,
and that's right.
Because it's just the
There's no
facts.
excitement.
And
It's just
Karen's
facts. It's
blushing.
Excellent, yes.
Well, and yeah, I get well, not yelled at, but it's reprimanded, shall I say, that you talk too long, It's like, well, stop giving me so much to talk about. Because there's a lot of times a lot that I've got to lay out
or
on the
anticipating the
table,
questions.
you know, and we do that not just for you, because you guys I'd like to think, have studied, read, and memorized the reports that we send you. The folks in the general public, not so much. And you've seen sometimes that it is an emotional, testimony for them about what's being proposed. So that presentation really is to make sure everybody in the room has those facts before we start into taking that public
Yeah.
testimony.
Yeah, that's great.
So,
And then,
Yeah, I look forward to the time that we ask Karen at a meeting sometime that says, hey, could you do your staff report as if it were a musical?
Yes.
be careful what you ask for.
and then we were talking about deliberations. I had it in a few slides ago, but I do want to point it out. Considering thinking out loud, you guys have been doing a good job. So it doesn't necessarily need to even be in the decision it can when you got, but deliberations, like each of you talk about a factor or you say, I heard this, but I also see these 4 factors. It's good because again, then the public hears how you're coming to that decision. They don't always have to agree with it, but you're coming at an objective way. You're looking at the code factors. You're not just like, okay, I don't have a motion. Then it's like, oh, wait, how'd they come to that decision? Especially if there's people in the room.
The one thing I tend to be very concerned with is where cross-examination has the potential to go sideways, where somebody from the public has provided testimony, and then you guys, you have other questions and you want clarification from them. Are they just answering the questions, or are they crossing over to providing additional testimony? Any pearls of wisdom?
Yeah, because once, so it's, I would say, bring that person up with caution, because unless like no one else can answer the question, because the person is gonna try to, and then it's up to the chair to say, oh, please just answer the question. We're up to our decision-making time. We're trying to make our decision. We're trying to get there, but it'll lead to that natural conflict when bringing back someone from the public. So I would say unless no one else could answer the question that the point that they brought up.
Because, yeah, if they seize that opportunity to do additional lobbying, the other side, whoever that is then gonna think, well, that's
That's a
fair, and well, we deserve more time, and then you end up with this chaotic debate and you lose control of the hearing. So I, as a staff person, would recommend one bite at the apple, one opportunity for testimony.
Yeah, definitely.
And that's something I think I've done poorly, when I was chair, Nick, you gotta do better.
You're
And
smart
that is,
yourself,
and
Luke.
that
Man,
is,
that's a,
you know,
that's a
if
high
we
call.
call
Be better than
somebody,
Lura.
if we call somebody up to ask a question, probably to preface it and say, you know, we really just need the answer to this specific question that
Yeah.
we're asking for. We understand
Public
the
comments
rest of your
votes,
testimony.
yeah.
Now then ask the question.
Yeah, I think, and yes, and that question, public comment is closed. We'd like a very specific answer,
Yeah,
and
yeah.
because this is this is our deliberation time and not time for public testimony. Yeah, I think. we
And
should
I
keep
think
that
I was
as a
too
rule.
lax in a lot of that and let people ramble on.
I think you ruled with an iron fist.
So what do? You do appeals and you do variances. So we already spoke about the first part, when it alleged there's an error, and that actually word is important because that even when we had our last appeal, we said, well, but was there error? Not that you disagreed, was there an error in Sally Riley at the time's, letter of decision? Again, the chair is the presiding officer. That's clearly stated in your code. You administrate the order, the process. The appellant has the burden. If they're appealing, if they are saying that it was an error, the burden of proof is on the appellant. So that's important, because it's not the other way around, right? That they kind of question, sometimes people are like, well, how is this allowed? How is it allowed? No, you have the burden because you're the one bringing the appeal and you have to say that there was an error. They definitely have the burden of convincing you that the error was made. And if in the last appeal, we said that from the beginning, so everyone could hear that. I think burden of proof is important in any hearing, in any trial. And again, it's just reiterating your obligation, look at everything in front of you. What was appealed from, what is this final determination? The staff report, the appellant's arguments, you looked at the code, you heard the testimony, review it all. And then again, you could reverse or affirm, partly or wholly modify it as if you're rewriting it. And if another appeal comes back, we'll go over that. We'll explain to the public, what does that mean? Oh, hold on, can we just go back? Thanks. I just want to key in on this. I mean, we spoke about a few times with quasi judicial, but particularly with an appeal, it was an error made, not that you disagreed with the projects. That was the difficult, and I understood where the one in 2019, it was 100 homes that the person doesn't even own the property. It's there's even just opinions as to, is that fair for the consumer, but there was no error in the code or in the decision. So your opinion as to what would be better, or your preferences, or your feelings that your project should look, well, I wish they would have done this or that. That's irrelevant to the appeal. It's, was there error or was there not an error?
Is it, when there's an appeal, given that the appellant has the burden of proof, they essentially need to then bring, I want to appeal this specific fact. So what if, I wasn't on the board for that one, but I missed the fun.
Yeah, it was like
but-
2 a.m. That's 2 nights.
Yes.
Was the fun.
You were the.
Yeah,
But, as I understand it, the code was, we call it a loophole, call it whatever,
Yeah.
but the code was very specific.
Right.
But if the appellant came and said, hey, I think there's an error here because we're not allowed to have purple houses. And so the board hears the hearing, but in the hearing you discover, oh man, we really applied the code wrong. Are you only deciding what the appellant is asking? Hey, decide this one item, or are you
Oh, I
actually
see.
looking at the entire case?
So it expressly allows you to rewrite it as if you were the administrative officer. If it were me, I would try to keep it limited to what the appellant is bringing up. Unless it's something that's 100%
Unless it's completely
glaring.
egregious.
Yeah. If it's,
Okay.
yeah, that's what I would say if it were me. And this particular case, there was no error. It was just that people were like, how could the code have possibly
Right.
missed this? And that was the argument. It was just, this is what our property, and I'm not trying to dismiss it. But to your point, yeah, I would keep it narrowly tailored. unless it was completely egregious.
Okay,
And like 100, like 99 out of 100 people would say that that's how the.
yes, this is totally.
Yeah, otherwise there is some discretion in planning, in planning, so.
Okay,
Yeah, these are all good questions.
But
next-
again, that's where we, at the end of the day, go through and say why we made
right,
this decision, and you can pick through what the code says, what the other says, and say, there it is. It's,
yeah,
I understand you don't like it, but
yes. Now, I mean, to be entirely frank, I was thinking more like football replays and like. Do you
No,
have
I
to
hear what you're
specifically- You have
Yeah.
to specifically pick your thing, and but I agree, Lou, I think again, the explanation of exactly what's happening, right, makes people feel good and gives us more credibility, I think is.
not necessarily happy, but good.
Right, not happy, but well heard, right?
But I,
That's-
Heard, and
yeah,
the
I
objective person
understand where
would
you're
say,
coming from,
yeah.
kind of thing.
So you also do variance, that's most of what you do. So variances are next. So before going to the code, I thought, let's just go over generally what a variance is. This is in interpretation, also case law, and just how it's looked at in different, Colorado, actually all over. So it's a deviation from your standard zoning regulation. So there's Title 18, and it's, someone wants to deviate from those express regulations. So it's granted to the landowner. It's an exception. So it should be used very, very rarely, variances, because otherwise the person should either follow the code or the code should change. So, typically it said where a strict application of a particular regulation in Title 18 would result in exceptional and undue hardship to a property owner. And we'll go into it more, but that's not, oh, I'd rather have an extra room in my house. That's not undue hardship. It needs to be peculiar to the property owner and to the property. It's not meant to rezone or do something that they should be going to the planning department and trying to apply for. A lot of times, actually, maybe we can go to the next slide. Yeah, so if a lot is exceptionally shallow, if it's a triangle like shaped, the planners are probably cringing, but I'm talking as a normal. It's not a typical rectangle. That could be a reason because how do you calculate setbacks? Could a house even exist with that at that point? Or the same thing goes for topographical, like with a sloping. If most of your property is a certain grade, and you need to have your house, maybe back from where it should have been if it was just a flat property, that's probably fair because of those conditions. And you want to make sure it's relieved without detriment to the public good, without truly going in against the intent of a zoning code. Again, it's rarely given, and it should be in extraordinary circumstances and in conditions that are rare, like these unique shapes of the property. Let's see. Yeah,
I'm not sure if you may address this later, but
Yeah.
it seems like a good
no,
time.
please.
What is I was gonna say, what's the story with consistency? So, by definition, these things that are unique, right?
Right.
They're supposed to be weird exceptions, right?
Yeah,
I'll say the topographical one is the one that we see, I don't say most often, but seems to
Right,
pretty
in the
often,
park,
right?
yeah.
Like, we want a height
Mhm.
variance because it's really sloped. And
Mhm.
And I will say that my thinking on that has probably evolved over the last few years of being on the board, right? You see one and you're like, yeah, that looks really steep. Like, okay, sure. More to it, forgive me for the, being flippant. But as you go forward, you start to see more and more. This is, well, gosh, the town is pretty sloped. There's a lot of places that are sloped, and maybe you don't, maybe you can build a house, but sorry, your ceilings, you're gonna have to do 8-foot ceilings instead of 9 foot.
That's
right?
it. That's the point.
and you
Can
start-
you reasonably use your property?
Right, and you start sort of getting into these traits as you go forward. So the reason I bring that up, right, is do we have any, again, we don't want to be capricious. We want the public to sort of know what you're going to get, do we have any obligation or guideline to sort of be consistent in that application to say, hey, gosh, you know, every time we see this 15-degree slope, we give about a 5-foot variance and people can expect that. I'm wondering, I'm just, it's something that's sort of chews in my head. I'm not looking for.
Yeah, no, I do have an
a
answer,
straight
because if
answer,
you ask me in a public hearing, which you might, I would say there's no precedence in variances, because it needs to be that it's very particular to that
Yeah.
property, and
Yeah.
I understand where you're going, and you're like, oh, but you just told us to be fair. I will always say that because it's a particular situation, and you really should only be giving it in limited circumstances, and based on the unique facts that are in front of you. And then I even say that I see this all the time that, oh, well, it would be more convenient if I had this sunroom, or that's not, that people need to follow the zoning code. They usually probably purchase the property with, notice after the zoning code was enacted. And, it's only if they don't have any reasonable use of the property. And I would say an exception to that is if it's like an ADA reason, you know, that.
Yeah.
That
Yeah.
you should, that
Now,
trumps.
Karen
Yeah.
has reminded us on numerous occasions when I've asked, what have we done? How many times have we given variances in this area? And she reminds us that, hey, each variance stands on its own. So in that
He
regard.
just wants to see if he's gonna get the same
Yeah.
answer from me.
See, I would
Yes.
contend, I would contend if you did want to do that, where this happened, there's always this answer. No, that requires a change in the code.
Correct.
Because, okay, that's a great,
100%.
I could totally.
When
wrap
I rewrite land use codes and I say, show me your last like 3 years of variances, and like, they're like, oh yeah, we always give for the last 3 years, every single one is about, so we're gonna change that part of the code.
Yeah, and I've worked other municipalities and done other code updates, and I will support Nina 100% on that. The consultant's going, what have you guys been varying?
Yeah.
You know, and that's part of, well, if you're handing these out like candy, that's telling me that there's a problem in your code.
it's-
So let's just fix that, so we don't have to torture our
And-
community with
and
the process.
I think before Karen came,
That
we've
makes a lot
done
of
some of that.
Yeah,
For example, in the inside of the horseshoe, there are a lot of small lots, and we've approved a lot of variances for the corner lot
Yes.
because of the 25-foot setback. And we had the planning department take a look at that as a potential code change. And what we found out was there were only about 4 left that were that way, so it wouldn't warrant it with.
yeah,
But the idea is to try to put ourselves out of business if we can.
yeah, no, that's a great answer. I appreciate
Well,
it.
it's not that you're
Yeah.
out of business, but you're definitely dealing with the ones that are weird, that are odd, that
Yeah.
are problematic.
Right. And this quote, I should have put which case is from, but please read it, because it explains why you shouldn't just give random variances and why the importance of zoning. You know, it says the whole fabric of zoning will be worn through in spots and raveled at the edges until its purpose in protecting property values and securing the orderly development of the community is completely thwarted. So that's just, from a case. And then now let's go to your specific code. So you have, this is what you specifically say in your variance, provision, that it's based on shallowness, shape, topography, other extraordinary or exceptional situations. Where if you're strictly looking at the code, it will result in exceptional, demonstrable, unnecessary hardship. So all those words are really important. Again, versus a convenience of someone who would rather have a second story to their home in that particular zoning district. And then you have 2 things, and you have this in your really good checklist that I think we've created, but for Karen, I'm not sure. Your findings and you have your conditions. So the applicant has the burden. Well, that's my second part, but the findings are this. Like, if you don't even have these findings, then we don't move forward, right? So you have to find those. And then who's the burden? The person who's asking for the variance has the burden to demonstrate all of the following conditions. That's what how your code's written right now, that all 4 of these exist. So yeah, you have done a good job of deliberating and going over, one person's maybe going over one person's going over the other.
That's one of the questions that I try to remember to ask. When the talk, part of this is does without the variance being approved, are you at a disadvantage compared to the other people in the area? That's one that I would ask the applicant to really define. What is your disadvantage? Tell me, compared to the other guy.
Yeah, and go back to specifically what it talks about in the same zoning district. Is that really talking about, I want to ask this, if they're, oh gosh, I'm gonna botch, somebody throw out a zoning, but like commercial, urban, or residential, or, suburban residential, right? So is it, that's this one, right?
Uh-huh.
Okay, good. Sorry, my brain was blanking and I was just like under the gun. So, so if I said, hey, my property is in suburban residential, am I comparing my property to all suburban residential within Woodland Park, or am I comparing my property to suburban residential in like whatever my sort of little chunk is? So when they say sort of in the same zoning
Oh, it says
district,
it's
what is same?
Which bullet?
The
point?
last
Looking
one.
at the third,
It says
Or-
same zoning
fourth from
district,
the
so I would
bottom.
say the district itself, that.
Yeah,
whole
I was gonna say
district.
what's allowed under the code.
within the code,
Right,
that's
that's right.
okay, not some small, this one over here.
No, the whole,
versus-
any
okay,
part of the
anything in there.
because it's,
okay.
like, let's say it's a height variance, everyone is reading the code and saying, well,
30 feet.
we only could do 30 feet, and then you're coming and you just want 35 feet because, that's not fair to the other people who are just like following the code, that's how I kind of read it.
No, what I meant was,
It's the whole, any zoning, anyone.
and
that's
any zone, right, so if
Yeah.
I have these like 5 houses over here that are all on a hill, but there's 1,000, the 5 are actually special, it's not, well, gosh, your neighbor's about the same, and so you get that, okay.
Yeah, it's more looking at the whole zoning district. So any questions about, this is our last slide, I think, any questions about variances or appeals, or? This is just particular to the open meetings. You are a board or commission that is subject to the open meetings law. So I'm not gonna go over all this, it's just good to know, but what's important to you is that you don't speak about anything substantive with each other, electronically, via email, text, because you could be creating an open meeting that wasn't noticed, because there's no way to notice Lou Ramon's group chat, right? So, that's, it could be like, when's the meeting? That's the actual statute was changed in 2021 to say that it's not just, because there were some people who are nefarious and like just replying all to try to get the city in trouble. It's not, wait, is the meeting at 6:30 or 6? Or Karen, it's snowing, is the meeting still on? That's fine, it's substantive, right? Because you want to think of, the public wouldn't care if you wrote that email, right? This is not what the statute says, but this is my way to explain it. The public would care if you were like, well, what do we think about, the variance code, or what do we think about that past, that's not really fair. But if you're just saying like, is there pizza before the meeting, and then don't text during a meeting. With staff lobbyists, I talk about all these different examples, because I've seen all of this happen. Because again, if someone in the audience is texting you, everyone should read that, right? I mean, that's very basic, but I know that I've seen this happen. It's a way to, again, for you, this group, I see it as a reason to explain to the person who's doing it. You could say, no, you can't do that. A good thing is just not to look at your phone, but I've seen it with mayors of cities that I currently represent, that I have to tell them. Please do not text the person in the room. They could come during public comments so everyone could hear. And that's particularly important in quasi-judicial. So yeah, you could have an executive session. We think we had one in 5 years ago. I think we had an executive session, but usually just council has one. In my boards of adjustments planning commission, it's very rare, but for legal advice, where I truly feel like it needs to be to protect the city, give legal advice. It's very rare in these types of boards and commissions, but you do have the right. And if you do, it needs to be 2/3 present voting for it. And it needs to be specified bases.
Can you give me an example of, like, I would think, again, I'll go back to legal advice of, hey, are we allowed to do this, right? I mean,
Right.
again, very sort of bluntly, I could see doing that in a public meeting, right? Hey,
Right.
we're looking for advice from
Yeah.
council, and that's a great thing, right? In the
Yeah.
sense that, hey, we're going to the expert
Right.
giving opinion, we're then going off and doing it. When would someone go to an executive session? More of just like, not that I would do that all, but how would I use that tool?
You would call it for it, pursuant to, the specific statute, and you could ask the attorney for help, and it would be for probably legal advice. Where I've seen it happen for, boards of adjustment and planning commission, again, very rare, but it's legal, is yeah, a lot of times when you guys ask me legal advice, I'm either gonna answer it or I'm gonna answer it vaguely and you're gonna be like, why is she doing that? It's because I don't want like a person who's gonna then be adverse to the city to hear it and take it. But a lot of my boards can read between the lines and understand what I'm trying to say. But sometimes they can't. And so if I feel like I'm gonna I need to preserve the procedure of this hearing so that it's fair, and I need to have a very stern talk with my board, then I might ask if someone wants, I can't call it, you'd have to make it.
Well,
Might
we-
make a,
we
might
had-
recommend a motion for.
Mhm.
executive
Yeah, we had a situation during the appeal. Where,
I thought so, yeah.
where we wanted, some of us wanted an executive session to talk some legal matters in there, and
But we don't have
the
two-thirds,
board
right?
did not approve
Yeah.
that. Okay.
So there's only so much I
The
can say
motion was made, the
publicly.
board didn't approve it. Now, in our procedures, we're not telling us how to vote, but generally the guidance that we put in the rules of procedure kind of indicates if somebody feels that we need an executive session, unless you really think that that needs to be discussed in the public
Privacy.
forum, accept it and let's talk about it in the executive session.
Yeah.
And we're gonna make
We're not,
sure.
we're not telling you how to vote. You still have that, but
But.
No, we wouldn't be able to, yeah. And then like just you, right now you have, I can just competent city attorneys that we're not gonna allow it to get into a situation where we're telling you what to do or we're going beyond the bounds. The open meetings law is sacrosanct, so we wanna make, like, we make sure of it too, you know, we're here to referee ourselves to, you know, as a city.
So in several decades of working in planning, most of it here in Colorado, I have never needed an executive session for planning commission or board of adjustment. So that proves the point of it being that rare. And when you guys get those staff reports and go through them, if you do have questions at a staff level, we love it when you reach out and you say, hey, I got questions about this, this, and this. Because that gives us a running start that we will work that into our presentation 99% of the time. So that was, my theory is if one of you has a question, probably somebody else does too, whether it's you on the board or in the audience. So that gives us that ability to kind of like fill that in for you all. Or if there's a question that's coming up that's like legally making my spidey sense tingle, then I'm calling Nina in advance of the meeting going,
Yeah.
hey, I'm concerned about this.
Definitely.
I just want her to be prepared. And then if it's also potentially something that I can, you know, we can work into the presentation to kind of answer it that way. So we do work behind the scenes for you, for the community, for the integrity of the process. So,
and
So
then
now I've-
the moral of the story is when we get that staff report, even though it says preliminary, if you have questions on certain parts of it, fire an email back to Karen and ask that so that they can dig into it and give us an answer and don't get blindsided when we're in the meeting and have to.
Or they have time to look into it.
Yeah.
Because then again, the
We
public
wanna
will
have
hear
the-
the answer
The
too.
best information we can to make the best decisions.
Yeah, see, and I've always thought that because of the open meetings law, that
Staff does not include.
I can't I couldn't send a question to
to
you
me,
ahead of time.
to staff, no problem. Don't reply all.
So just
Just
to you,
staff.
not to the
Right,
members.
right.
And
I-
what it'll do is it does achieve a transparency because like Karen said, she's gonna address it in the staff report so that everyone could hear. So it's
Or-
not like it's this nefarious thing just for any public person listening. But the open meetings law doesn't apply to staff. But
Okay,
again, Karen will use it to then transparently say, and then she'll be able to look at the files and get the question versus you ask something about a property file that's, you know, she's gotta look in 50 years ago. She'll come prepared with that. And then everyone hears
And
it.
if the staff, if when they do their presentation or revise the staff report, if your question is not answered, then ask it again.
Yeah. And there are times when I'll even reply, it's like, great question, ask it at the meeting, we'll answer it. So not to steal your thunder either, you know, that
Yeah.
there's like a balance between that. So some of it's whether it should have been in the staff report and we dropped a ball or, just.
yeah,
or
'cause I've never
easy enough to
considered
clarify.
sending a question.
No, I'm,
to you or any other
Yeah, please do.
member
Or
ahead
call
of
me,
time.
it's legal
Yes,
question
I
or.
do that.
Well,
Hopefully change, that
You
was.
can. As long as you, as Karen said,
Don't
don't
do
hit
reply all.
reply all.
I
and
don't
I'm,
reply all to anybody.
if you're emailing one of my team members, 99% of the time it's CJ, if you can include me also, that's just helpful so that if I see something, I make sure that, we're on it. It just
Well,
helps.
And
Um,
copying you
both of
like
us.
does not violate,
Yeah, it's all
No.
staff.
does not
staff is not.
violate the open meeting laws.
And then also again, the philosophy of the open meetings law, because now Karen's gonna come better prepared to answer the question that everyone
I
else
just
could
always wanted to
hear.
stay away from it.
I know a lot of people like in my council, like I have a city that has a lot of new council members, they have the same reaction, what? And they're like, can I ask that during the meeting? I'm like, please ask that during the meeting. So now I could answer it and everyone could hear.
Yeah.
But
And-
I will be more, not like it's about me being more articulate, but I could research it, have a comprehensive answer, same thing as Karen, so that everyone could be benefiting from that. So if you do know you do have a question, it does help us because we will come with a more prepared answer too. That's research and based on
Mhm.
what we've,
And Nina
files.
knows I am not shy about speaking up to her. Either like, hey, I'm worried about this going sideways during a hearing. I just want you prepared,
and that
or
helps me because then I'm ready.
yeah, help me in terms of like, what am I doing with this? So it's just when, that's my reputation is if I'm crying wolf, there's a wolf, it's.
Yeah, oh, definitely, yeah. 'cause
Yeah.
I have other planning directors and I'm like, every little thing is not an issue. But if Karen comes to me, I'm like, okay, she knows, I'm gonna look at that, I'm gonna keep an eye, I'm awake, but I'm gonna be particularly awake during that. Or I'm just gonna have an eye towards it, but yeah, please ask questions to both of us,
And I'd like to think that, if we have a question on something in the staff report and get it to Karen and CJ and the team, that they may even wind up asking the applicant for some information or two, that the applicant might even want to tell us more when they make their part of the
and
presentation.
then they have more
too. I
time
mean,
to put it
the whole
together.
thing is to get the best information
Right.
that we have, so we can make the right decision.
Yeah, a clear and complete record.
And then people also like, I'm not sure about how much this applies to board adjustment, but people would say, well, can I ask this question? I know the answer, but I want the public to hear. So, or sometimes I think one of you have done this, it's like, I'm gonna ask you this question so everyone could hear, because I think this distinction is gonna be missed. And I wanna ask it in a way that it's a question that people hear instead of me just, saying it. So we're here for you.
I like it. Thank you.
Yeah, questions, comments. If you have, my email was at the beginning, you'll be seeing either me or Betsy. You saw her at the last,
What did you
meeting.
say her last name was?
Stewart.
Thank you.
Yeah, that was.
With a U or a W?
A W, that was a typo. I didn't mean just to put her Betsy Stewart. But if she ever emails you back, you'll see her last name. Sorry about that.
Since she was just an associate attorney, so I was like, maybe you don't get a last name.
You don't get a last name.
Oh, God, I know, I'm so embarrassed that I did that.
And she is listening
Yes.
electronically,
Yes.
just
W.
FYI.
Yes, yes. No, yeah, that was
I've
definitely.
heard
an
she's
error.
laughing.
Yeah, no, that was definitely an error,
So
and I
We
can't.
also appreciate you, Betsy.
Yeah, it's different when they change the name of the company again and add Stewart to it.
Yes. Well, it sounds like that maybe is the end of our work session. Are there
I
other?
got one
Oh, please, Lou.
nitty question that came to mind after looking at the proposed changes to the code and realizing what's in the code already. Is I get a little confused when I see about recusing yourself or recusals and being exempt from voting. There's a statement in the code today that says any member refusing to vote,
Which code section are you in?
it's in 1851-050, last sentence.
Yeah,
Oh,
we could
50.
delete this.
Go ahead.
Says any member refusing to vote except when excused by unanimous consent of the remaining members present shall be considered delinquent. Okay, but it says an affirmative vote shall be cast and recorded in his or her name.
When I was reading
Now-
it,
now-
no, this made me cringe. If we could remove this sentence from the code.
Well,
Okay.
the question I had was for recusal. Does it take, if someone says I have a conflict of interest, or I feel there'd be a perception of a conflict of interest, and I'd like to be recused, does it take a unanimous vote of the board for that person to be recused? Or are we in a situation where somebody could point to this thing and say, oh, wait, you know, if that person's recused, you shouldn't have appointed somebody, or, you know, you didn't approve that person being recused.
So the
You shouldn't
lawyer,
have appointed somebody else, and that should be a
Yeah.
yes vote for
Lawyer
my,
says-
my.
the lawyer in me says it says consent. So how do you define consent? I would interpret consent that none of you spoke up against it. But that being said, I would like us to delete that sentence from the code because it could be confusing. Because I agree, someone might be like, well, unanimous consent, it doesn't say affirmative vote. It says consent. So I feel like if you say to everyone that you're gonna recuse and nobody argues with you, that's unanimous consent. That's how I would interpret it, just to keep, the procedure, typical. I would say that unless someone speaks up and argues with you, then there was unanimous consent. But I do agree, I didn't include it in the training. I was like, I need to speak to Karen. I do not like this.
Yeah, and I just, I overlooked
Practice
that
this.
sentence
Yeah.
until a couple of weeks ago.
Can you go back to the piece that said if you refuse to vote, an affirmative vote will be cast in your favor?
In
Yeah,
that same
That's what the code
situation.
says.
So,
In that same situation, but again, if it says, it doesn't say affirmative vote, it says unanimous consent. So I would say that in this, that's why I would like this sentence deleted, but I would say, I would argue that if Lou says he wants to recuse himself and nobody argues, that's unanimous consent. If one of you does argue, then you're gonna get into the situation where, that's why I don't like the sentence, that an affirmative vote, I feel like that is, can cause a lot of issues procedurally. That if somebody's vote, because how do you make someone vote some way if they wanted to recuse?
right, they wanted to recuse.
And what's
themselves.
affirmative? I mean, it's voting for what's in front of you, but, for an appeal, you could deny, right, the appeal,
Right.
you could
To
deny.
any motion, I would say to any motion. So if I made a motion to grant the variance,
And all of a
Jim
sudden I
said
jumped up and said, I gotta.
Jim
recuse
wants to
myself.
recuse himself. Val doesn't think so. She thinks that's a bad idea, so it's not unanimous
Right.
consent. And then.
Well,
by
except you have to
definition-
recuse yourself at the beginning of the meeting.
Right, no, well, yeah, but Jim's still just not gonna say anything. Can't force it out of his mouth,
Oh, because he's refusing to vote. Yeah.
because he's refusing to vote, so all of a sudden it turns into an affirmative vote.
We should, yeah, can we delete it?
Right, oh, yeah, I'm happy to.
Because I didn't even include in the slides. I was like starting to, and I'm like, no,
Well,
because
here's.
Now, I've never seen this come up.
right, because it would only
but-
be if someone didn't agree with the fact that you're
Yeah.
recusing.
We could make this, we could all make this happen though.
Oh, yeah.
But,
No, please.
so,
It'd have to be on April 1st.
yeah, so I guess what I would say here is let's take that out of the. code.
Yeah, because I see legal problems with
yeah.
this, how this could happen.
And in
because-
the
yeah.
interim, let's try not to do that. But if we did,
Right.
I'm-
Right, this group of people, you're not gonna.
but,
yeah.
but I'm gonna say if we did, I'm gonna go back to, this sounds like a great executive session.
Yes. Because then I would say, listen, we have more legal problems if you go this way, because how can you force someone to vote? This causes so much, if this would actually be played out, it would cause, it could cause an arbitrary decision, because how could you force someone to vote a certain way? And then what's an affirmative? Because in the appeal, you could deny, what is it? You could rewrite it, you could deny in whole or part. There's a lot of decisions, like different ways you can go with the appeal. So is affirmative just the first person who made the motion? It's, yeah,
Like a lot of sections of our code, it leaves a lot to be desired.
but that we could just delete that one sentence.
Yeah. I made a note of that.
Yeah, in practice, if it were, I could see, I mean, a few years ago, if this was a different, well, not you guys as the board, but in, future other boards in the city, that this could be misused. I'm okay in the interim before it's deleted, because I know you're not gonna misuse it, but there could be a different board in the future. That's why in the future I would like it to be removed, but.
I would also advocate.
Because
for-
this could cause a lot of legal
Yeah.
problems. And when I saw it, I was like, oh, goodness. I'm not gonna train them on that.
Thanks, thanks Lou for finding that one. Do we have any other questions or comments?
No, I've done my damage.
I would just say thank you. This has been
Yes,
good.
thank you very
Yeah,
much.
thank you, Nina.
And if anything comes
Oh.
up, feel free to ask a question like, oh, I forgot to ask this, I forgot this. Cause we're here to make your, like you said, make your board have that credibility, that make those decisions that you feel comfortable in them. Again, not everyone's not gonna get everyone happy, but you feel comfortable with them. That's what's important.
Excellent. Thank you very much. Moving on, is there any staff reports today?
I just want to thank the various members of the Board of Adjustment that have been sitting in on all of those work sessions we've been doing around the code update. Valerie has by far been carrying the banner for the Board of Adjustment. She's doing a great job on your behalf. And it has been helpful to have her join us for those. And so I'll be keeping you guys apprised of when those happen, just the way we have been, and hopefully need to get this wrapped up pretty darn soon. I've said this before, that this draft that we're getting pulled together, once we get that solid draft, it is going through Nina's office for a legal review. And then it'll go out to the public and through adoption hearings. So that is the path forward for where we are.
Getting exciting.
Yes.
Well, thank you for all the work. Thanks, Val. Appreciate that for carrying the water for the
I
board.
was grandma last
Oh.
meeting, so.
Congratulations.
Well, no, I mean, I already was one, but I had to help.
Gotcha.
With nothing else from the board, we can adjourn the meeting. So, thank you.
Okay. Thank you, everyone.
Thanks so much.